Hello everyone. I'm Amulya Legan. I'm an assistant professor at Jamalal Bajaj School of Legal Studies, Banastari Vidyapeeth. I'll be your host for the subject Indian Contract Act 1872. So let's begin with it. So today I'll be talking about the introductory part for this particular session. First of all, what is a contract? As per section 2, subclause H of the Indian Contract Act 1872, it says that an agreement enforceable by law is a contract. Now, a contract basically is an agreement between two or more parties which the law will enforce. According to Salmon, a contract is an agreement creating and defining obligation between the parties. So basically, any kind of agreement which is lawfully enforceable by law is called a contract. Nextly, what are the essential elements of a valid contract? So the essential elements have been given under section 10. All agreements are contract if they are made by the free consent of the parties, competent to contract for a lawful consideration and with a lawful object, and not hereby expressly declared to be void. So we'll look at them one by one. Lawful consideration. So consideration is to be in terms of money, the currency which is there available in the country or territory in which the contract is done. Consideration must not be unlawful, immoral, or opposed to the public policy. For example, A wants to buy a watch from B, and in return, as a consideration, A wants to sell his wife. So this is unlawful consideration, which is immoral in nature, and even it's opposed to public policy, and the law prevailing in our country also prohibits the same. So talking about the lawful consideration again, A wants to sell the watch to B for rupees 2,000. So this is a valid offer as such. Next, capacity. The parties to a contract must have capacity. So this capacity is the legal capacity to make a valid contract. Means all the parties to the contract must be legally capable to get into a contract. Section 11 of the Indian Contract Act specified that every person is competent to contract, provided is of the age of majority according to the law which he is a subject, and who is of sound mind and is not disqualified from contracting by any law to which he is a subject. So over here, under the section 11, three category of people has been declared to be incapable or incompetent to get into a contract. First one is a minor, the person who is below the age of 18 years. Second one, the person who is insane or who is not of a sound mind. And third category is the person who are disqualified from contracting by law. So we look at them again in further sessions, which will only focus on this competency of contract. Person of unsound mind can enter into a contract during his lucid interval. So now lucid interval is when the person is capable of understanding the nature of contract. At that time he can get into a contract. An alien, enemy, foreign sovereign, and accredited representative of foreign state, insolvents, convicts are not competent to contract. Next essential element is free consent. The consent of the parties must be genuine. Consent means agreed upon in the same something in the same sense. Consensus at adeem means both of the parties are agreeing on the same subject matter with free consent. A consent is stated to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Lawful object. Object of agreement should be lawful and legal. So take the same example. A wants to sell his watch to B. So this watch is what? This is a lawful object. Two persons can't enter into an agreement to do a criminal act. Consideration or object of an agreement is unlawful if it is forbidden by law, is of such a nature that if permitted would defeat any provisions of any law, is fraudulent in nature, involves or implies injury to person or property of another, court regards it as immoral or opposed to public policy. Next essential element is possibility of performance. Means the terms of the agreement should be capable of performance, that they can be performed in future. An agreement to do an act impossible in itself can't be enforced. For example, A agrees to B to discover treasure by magic. The agreement is void because the act in itself is impossible to be performed from the very beginning. This is also called void ab initio, something which is wrong from the very beginning. Next essential element is not declared void. The agreement should be such that it should be capable of being enforced by law. Certain agreements have been expressly declared illegal or void by the law. So such illegal or void means wrong agreement should not be done. Other essential elements also include necessary legal formalities like the contract may be either oral or written. Where a particular type of contract is required by law to be in writing and it should be registered, it must comply with the necessary formalities like it should be in a written form, it should be registered and it should be attested. If legal formalities are not carried out, suppose means like oral contracts are also valid, and if the legal formalities are not carried out, then the contract is not enforceable by law. So for now, I'm done with all the essential elements of a valid contract.